So, when a massive new law is passed, how does it actually get switched on? Does it all just happen at once with the flip of a single switch? Well, today we're going to take a deep dive right into the engine room of legislation. Think of this as a masterclass in how a really powerful new law, the Sentencing Act 2026, is brought to life bit by bit. All right, so here's our game plan. First, we're going to get to grips with the new act itself, this huge new machine for the justice system. Then we'll find the actual key that starts the engine. After that, we'll see the first parts fire up, some really big changes to bail, and then some totally new rules for recalls. And to wrap it all up, we'll take a peek at what's still waiting in the wings.
So, let's kick things off with our main subject, the landmark Sentencing Act 2026. Now, this isn't just a minor tweak to the system. No way. This is a fundamental piece of legislation, and it's been designed to totally reshape some pretty significant parts of the criminal justice system here in England and Wales.
So, on January 22, 2026, the Act gets what's called Royal Assent. You can think of that as the final seal of approval that officially turns a bill into an Act of Parliament. And its purpose is incredibly broad. I mean, it's aiming to reform just about everything, from how sentences are decided in court to how and when offenders get released, all the way to the rules around bail. It's a massive undertaking.
But here's the really crucial question. Just because this act exists, it's on the books, does that mean all its new rules are actually in effect? And the answer, which might surprise you, is no, not at all. A lot of the act's most important provisions are what lawyers call prospective, which basically means they exist on paper, but they're dormant, just waiting for the signal to go live.
Okay, so if the law isn't on automatically, what is it that wakes these sleeping sections up? Well, this brings us to the actual mechanism that activates legislation, and believe me, it's a very deliberate and controlled process.
The answer is something called a Commencement Regulation. The best way to think about this is like it's the key in the ignition for the new law. It's a totally separate legal tool, a type of statutory instrument that the government uses to set the exact date for when specific sections of an act will come into force, and this allows them to do a controlled, phased rollout. And this lays out the whole journey perfectly. Parliament passes the act, it gets royal assent, but nothing really happens until the government issues a specific commencement regulation. Only then are the individual parts of the law switched on and become active, enforceable law.
So, what was that very first turn of the key for the Sentencing Act 2026? Well, the first set of changes, brought to life by the Commencement No. 1 regulations, focused squarely on the rules for bail. So on March 22, 2026, the very first part of this new act officially came into force. Its whole job was to make some really crucial updates to a much, much older law, the Bail Act of 1976. And this is a perfect example of how legislation evolves over time, with new laws kind of reaching back to amend and modernize the old ones.
And listen, these are not just some technical, stuffy changes. They have a huge real-world impact on decisions being made in court every single day. The law now changes the no real prospect test, which is what helps a court decide if keeping someone locked up before their trial is justified. It also tweaks the rules for when electronic monitoring, tagging, can be used as a bail condition, and it updates the list of factors that courts have to consider when they're making these massive decisions.
Now, just 9 days after those bail changes, the government turned the key again, this time activating a much larger and, frankly, more complex set of rules. This next wave, starting on March 31st, fundamentally changes how prisoners are dealt with when they get recalled to custody for breaking their license conditions.
So on this date, a whole new set of rules was switched on, designed for a complete overhaul of the prisoner recall system. Now, this applies specifically to offenders who are serving what are known as standard determinate sentences, basically a sentence with a fixed length, not something open-ended like a life sentence.
And if you want to boil this entire reform down to just one thing, it's this number, 56 days. This is the new, fixed period that the vast majority of offenders who get recalled will now have to serve in custody before they're let out again.
And the difference this makes is just huge. Under the old system, a recalled prisoner's future was often totally uncertain. They could be waiting for months just to get a parole board review. The new system gets rid of all that variability and brings in standardization. For most people, it's now a fixed 56-day period in custody, and then they're automatically re-released. This creates predictability, not just for the offender, but for the entire justice system. It makes it way easier to manage prison populations and resources.
But look, you can't just apply a new rule like this overnight to everyone who's already in the system. It would be chaos.
So the regulations created a phased rollout for prisoners who were recalled before March 31st. The new rules were applied in waves, and it was all determined by how long their original sentence was. This isn't just about being fair, it's a logistical necessity. It gives the prison and probation services time to manage all the admin, update their computer systems, and train their staff without being totally overwhelmed.
So the engine is running. Some key parts of this new machine are now active. But it's so important to remember that this commencement regulation was only number one. A huge amount of the Sentencing Act 2026 is still prospective. It's still parked in the garage, just waiting for its own activation key.
And some of these dormant sections are incredibly significant. For instance, the part of the Act that creates a presumption that any sentence under 12 months should be suspended, that's not active yet. Neither is the new requirement for courts to make a formal finding of domestic abuse during sentencing. Other massive changes like new income reduction orders or extending whole life orders to cover the murder of probation officers, all still waiting for their commencement date.
And that really leaves us with a final thought-provoking question, doesn't it? We've seen the what and how of all this, but what about the why? Why choose to activate these specific rules on bail and recall before everything else? What does this staggered, strategic activation really tell us about the government's immediate priorities for the justice system right now? And that right there is the art and science of putting law into practice.